Thank you very much for joining us today. The topic on the agenda is flexible working, so nothing quite like it to start the week off. For those who I've not spoken to before, my name is Kerry. I'm a director in our Glasgow employment team. What will we cover today? Just a sort of brief overview. Firstly, it'll be an introduction to flexible working, setting the scene and the context of what we're going to be discussing in a bit more detail. I'll then look at the legal position, the boring bit, arguably, the black letter law, and what your requirements are as an employer. We'll then zoom in on particularly refusing requests and some tricky situations which can arise, as well as then covering any key considerations, key takeaways to remember going forward before turning our attention to the Employment Rights Bill and the anticipated reform in this area as a result of Labour coming to power last year. So in terms of setting the scene, well, the reality is that flexible working is not new. It's been here in some shape or form since 2003. Historically, it was only for parents or for carers to have the right to request flexible working. Now it's expanded to everyone in theory, albeit I imagine most of the requests will still have that as their motive behind it. The legal landscape has changed slightly, I would say, over the years. And one thing which is, or one piece of criticism which flexible working has attracted in terms of the legal piece over the years is that some people say it's, quite toothless piece of legislation. It's a right to request working flexibly. It's a procedural right. It's not a substantive right to have flexible working. But I do think that there's some more interesting pieces around the edges in terms of the wider context. The possibility for discrimination claims is a big one, which we'll obviously come back to in more detail. It'd be remiss not to in this context, but also how things have changed in terms of society and attitudes, particularly as a result of COVID and the pandemic, which has obviously, come fast forward and accelerated what we've managed to achieve in terms of proper flexible working, hybrid working in a way that would have otherwise taken decades. And I think if there's one good thing that can come off the back of that it would be that we can embrace the opportunities available to us now, largely as a result of technology. But of course, as you'll appreciate, with every opportunity, there's challenges as well. And I do think whenever I talk about flexible working to HR professionals, it's a bit of a bugbear. You hear this collective sigh. Whilst there are some real benefits, obviously, in terms of allowing a better work balance with home life, it can also help accessibility and equal opportunity for those who couldn't otherwise work. Another real benefit I see is opening up a global market. If a job can be done remotely, then you've suddenly got a larger talent pool to draw from. But of course, there are negatives and at least challenges that we have to deal with. And I think more and more as we get further away from post-COVID lockdown, we are seeing a difference in terms of approach. I think the reality is it's difficult to find a perfect fit for every organisation. It very much depends upon your individual circumstances. One of the challenges, of course, is everyone working remotely. There's a lot less interaction in the office. We don't have those water cooler chats, which arguably are invaluable for sharing ideas and indeed for arguably junior members of your team to learn by osmosis, when they can hear their senior counterparts having conversations, and they can pick up on those as a part of learning. Arguably they're just not privy to it in the same way as if everyone's working remotely from their homes. I think one of the big challenges obviously is very dependent upon individual circumstances. How easy it is to supervise or to measure performance really depends upon your organisation and the work that you do. And there's some real questions about how healthy it is to be working at home all the time. If you're set up so that you're working in your kitchen, that when you finally log off at night and you move a couple of meters to make your dinner and eat it, is that really healthy from an employee's welfare perspective? And indeed, the mental health piece is obviously really important right now, given the challenges that every organisation that we advise faces in that respect. Again, if someone was struggling, you may see them in the workplace looking tired, looking stressed, looking fraught, working long hours. You would know to intervene, but you arguably lose that opportunity when it comes to people working remotely. There's other issues, of course, without being too negative, but a lot of people criticise remote working as actually potentially exacerbating the gender gap insofar as if women, predominantly women, work from home, whether that can actually make them less visible. As a result, less scope for promotion, for big wins, for job opportunities. And so there is obviously a balance to be struck. Other issues we see and advise upon is the difficulties in terms of employers having these offices, which can be quite expensive with big leases. There's no point in having them for them to then be left empty. So as a result, do you require everyone to come in for 1 day a week, but then there's not enough desks? And likewise, one of the difficulties with flexible working is it can be quite divisive, depending on your organisation. If there's blue collar workers versus white collar workers. Some can work from home, some cannot, whether that creates grumbles and grievances. And then at the other end of the spectrum, some of the more interesting questions which I've had in the last few years, mostly post-COVID, is employees working abroad but haven't told their employers, and it's only come to light because obviously it can be quite difficult to police if someone is full-time working from home. And this can be a massive challenge for organisations in terms of whether the employees accrue any employment rights in that foreign jurisdiction, or whether there's any tax or social security penalties that are attracted as a result. And lastly, of course, you can't really talk about flexible working without thinking about recruitment and retention and the expectation from job candidates as to what they're looking for and what your competitors are offering. I read an interesting article the other day which said that employees would take a 6% pay cut at least in return for flexible working from home, because it was seen as such a benefit. So, obviously there's a lot of various factors at play here. So moving on, before I really get into the legal nitty gritty, keen to hear from yourselves as to what your experience is in your organisation, how you see flexible working, what are the challenges, how it's changed over the last few years for yourselves, and indeed, whether there's anything that you want to cover in today's seminar, because as I say, we've got a small number, so it really lends itself to discussion if you're so willing. So, in terms of flexible working, what is it? I mean, ultimately, in terms of a bit of an overview, flexible working can be anything, really. The reality is it's not limited in terms of what an employee can ask for. So, typically, it would normally be a change to the working place, whether they want to work from home or elsewhere, or alternatively, the number of hours they do, whether indeed it's to increase or decrease, and more commonly, the times or days that they work. So as a result, you can get requests for any sort of arrangement, whether it be annualized hours, flexi time, job share, full-time, part-time, shift working, staggered hours, term time working. The list is endless. There's really no limit to what can be requested by the employees. The overview of flexible working, well, we have seen some changes in this area over the last year or so. The thing to remember from your perspective as to who is entitled to make a flexible working request, well, the important point is that it is required to be an employee, so not your worker population, albeit I appreciate that can be a difficult distinction to draw in practice. But likewise, obviously self-employed contractors cannot ask for it, it's got to be an employee. So as a result of changes last year, 6th of April, it is a day one right. So there is no service criterion anymore. It used to be that you had to have 26 weeks service before you could make the request. That's no longer required. Someone can come through the door and ask for it as a result, simply by virtue of their employment. The request can be for any reason. It doesn't have to be to do with childcare or carer responsibilities. The reality is that that's not relevant to the process, the subjective reasons behind it. It can be for any reason whatsoever. There is now a requirement to deal with the request reasonably and within 2 months. So this is again a change that we've seen over the years. Under the previous regime, it was very prescriptive in terms of the time scale and what you had to do when, in terms of acknowledging the request, setting up a meeting, responding, going through an appeal, offering a final decision. That has all been done away with. And then what was introduced was initially a 3-month period where an employer had some flexibility to deal with the request as long as he did reasonably and to issue a formal outcome. That was reduced down to 2 months as of April last year. Interested to hear what you think on that particular piece. From my perspective, it seems like 2 months should be a sufficient period of time to come to a conclusion on that front, albeit I anticipate normally what the issue is in terms of making managers come to the table and commit. And from your perspective as HR professionals, it is a bit of a liaising piece. So as I say, now the focus is that employers have to deal with the request in a reasonable manner. There is no statutory definition of what that means exactly, which is perhaps unhelpful, but the reality is it's quite a familiar concept in employment law and really boils down to fairness effectively. And what we have now is the ACAS Code of Practice, which basically sets out the basic minimum of requirements that you have to take in order to be seen to be dealing with a request reasonably. 9 times out of 10, it will be necessary for you to consult with the individual and always will be required where there's a refusal or a variation of the request. The only time where you can get away with not consulting with the individual is if you were wanting to grant their request in a straightforward manner without any qualifications, which I imagine is probably relatively rare, but could be foreseeable if it was a smaller, more simple request. Now employees have the opportunity to make 2 requests in a 12-month period. Previously, it was 1. And if the change is granted, ultimately, it will constitute a permanent change to their T's and C's. But there is nothing to stop individuals and their employers from dealing with informal requests out with the statutory regime. So as I touched on, I'll come back to we now have the ACAS Code of Practice, which sets out what is required really in terms of the employers dealing with requests reasonably. It's relatively simple, short, and we separately have the guidance, which is a bit more flesh on the bones. And ultimately, the Code of Practice can be taken into account by a tribunal if matters went wrong and a claim was raised. So moving on, in terms of what is required from the employee if they make an application, well, it's really fairly straightforward. The requirements are on the slide here, but the request must be made in writing and must be dated. It must state that it's made under the statutory procedure and have details of what the individual is seeking and when they want it to take place, and confirmation of whether a previous application has been made or not. Previously, there seemed to be a practice whereby employers would maybe be keen to try and throw requests out if they didn't meet the statutory requirements, take issue with any technical flaws. I think the reality is it's probably a bit risky to do that now and doesn't really get you much further forward, particularly that employees can raise 2 requests. And so normally it will be in your interest as an organisation to simply point the employee as to what mistake they've made and to correct it so that you have the information necessary for dealing and considering their request. And potentially a top tip, which I'm sure most organisations will probably do, is if you have a flexible working policy, just to include a form at the back of that which sets out what the individuals need to complete when making an application, so that you've got the information that you need to process it. So in terms of dealing with a request, ultimately you have quite a lot of scope in terms of, as an employer, only required to deal with it in a reasonable manner. But what does this actually mean? So if we focus in on the ACAS code, it suggests and recommends that employers arrange a meeting with the individual as soon as possible to discuss the terms of their request and understand the reasons behind it. I mean, the reality is that the reason behind it shouldn't necessarily impact upon your decision making process, but it can be quite helpful in terms of flushing out the risk profile of a request. For instance, if there are any protected characteristics at play which might have an impact from a discrimination point of view, which again I'll come back to in a bit more detail later, or indeed if someone's asking because of a health condition, if that could amount to a disability, it could be that actually there's an obligation triggered on the employer's part to make these requests as a way of a reasonable adjustment. So I think for more often than not, it generally helps to be forearmed with this information and to discuss it with the individual up front. In terms of the meeting itself, there's no statutory legal right to be accompanied, but again, ACAS recommendation is that it's most likely to be beneficial and in everyone's interests. And so similar to what you're used to dealing with, no doubt, when it comes to disciplinaries, grievances, an individual could normally be accompanied by a fellow worker or colleague, or indeed a trade union official or representative. The ACAS code also recommends that obviously the employee is notified of the employer's decision, but also a bit of explanation is provided as to your rationale as well. I think strictly speaking, in terms of the legislation, you could simply rely upon one of the 8 reasons for refusal, which we'll come back to. But the ACAS code suggests that you should go further than that and explain your workings effectively. And I would say that that is normally in your interests, again, for rebutting any potential claims of discriminatory motives being at play, for instance. But I think there is a possibility to be constructive and reach a compromise with the employee. It doesn't have to be a straightforward acceptance or refusal of the request. It may be that you can find a compromise solution that works for both parties. And what we would always recommend is that you document your decision making as part of your process so that you've got that audit trail to fall back on. One tool which we can exploit, and again I'll come on to it in the next slide, is the possibility of a trial period. These can be quite useful, or indeed it could be that you agree the request, albeit in a limited period of time, so it's a temporary or a fixed term in nature rather than a permanent, which I think employers don't always appreciate as an option open to them, and that can be quite helpful if you're wanting to build in some sort of flexibility without overextending yourself. And lastly, again, under the statute, under the legislation, there's no legal right of appeal. But the reality is, again, that ACAS recommend that as an appropriate step to show that you've acted too reasonably. So in terms of trial periods, again, there's no express right to this, but very often I would say it can be beneficial insofar as if you grant a trial period, then you're likely to have more of a better gauge as to whether the arrangement in practice can work or not, and have objective reasons for showing why it may or may not. The only thing I would say in terms of a bit of a health warning in this respect is the possibility that it can be more difficult to actually come back from granting a request once a trial period has been put in place. Because the reality is, if you've got a trial period for a few months and it seems to be working well, then it may be more difficult to show that you're reasonably refusing a request at the end of that period, particularly if employees have put in childcare commitments and arrangements accordingly. It can be much harder to scale back in that respect. But ultimately, the important point from your perspective is to deal with these cases on a case-by-case basis. Again, there's no prescriptive timescale as to how long any trial period should last. I think arguably it should be no longer than is reasonably required in order to gauge whether a request is going to work or not. But obviously, on the other side of the coin, you still need a sufficient time to properly assess. So I think something around the 3 to 6 month mark is probably going to be about reasonable. And again, there's nothing stopping you again from wanting to agree an extension to a trial period, so you can keep it under review for a shorter period of time and then lengthen it should circumstances dictate that. What I would say, however, is technically trial periods should be undertaken within the period of time, the 2 months that you have to respond to a request and provide a formal outcome. So if that is the case, then merely what you'll be required to do or be in your interest to do is to agree with the employee that you'll extend the timescale for coming back with a formal decision so that you can properly assess and put in place a trial period before you get to that stage. In terms of granting a request, obviously, arguably much less controversial if it is straightforward and you're happy with the proposal and you think that as an organisation you can accommodate it relatively easily. What is required is that employers issue what's known as a Section 4 statement. So you may be more familiar with the Section 1 particulars. This is the minimum requirement of information which employers are required to confirm to individuals when they start their job. And a Section 4 statement is effectively just confirming that one of those Section 1 particulars has been changed, been varied. And normally it would be in your interest to issue a contractual variation as well. So it doesn't mean that you have to issue a new contract, but normally just be a separate side letter which confirms the basis upon which the changes have been agreed and that they'll be contractual in nature. So effectively, unless you agree otherwise, once you've granted a request, the changes are a permanent change to the individual's terms and conditions. What can be more difficult is if you want to refuse a request, and this is where the legislation dictates that there are 8 grounds upon which that you can rely upon. The reality is that these haven't changed. They're quite wide-ranging, and it's probably not too difficult actually from the employer's perspective to be able to find a reason to rely upon, or indeed more than one, within these categories. Ultimately, they're all business reasons. So, arguably the whole point of flexible working is to try and make it work from the employee's perspective and their personal circumstances, but that's not what's required of you here. Interestingly, it's to determine how it works, whether it's operationally feasible from the business perspective. And normally you can suggest one or more reason that you rely upon. And I would say that normally that will be in your interests to hedge your bets in that regard, because if an employee can take exception as to your reasoning for one reason, then it may be that you've got stronger grounds in respect of another. Ultimately, this is where I think the legislation is not employee friendly, in that arguably the legal test is that you as an employer can make a subjective decision here, and it's quite difficult for the employee or indeed any tribunal to intervene with that, provided you can show that one of your grounds for refusing is based on these statutory grounds. Ultimately, unless there was a challenge that you've been using the wrong facts, basing your decision on the wrong facts, and it is difficult for an employee to object effectively. One thing that I would say, which is a common complaint I hear from our clients, is effectively it's not an HR decision. I think sometimes that can be the misconception within businesses from managers in particular, that a request has come in for HR to deal with. But ultimately, it's difficult, I would say, for HR professionals to be able to rely upon these refusal request grounds. It's much easier for a manager to be able to objectively assess the factors at play here and to show their reasoning. So I think, ultimately, if you do receive pushback in that respect, then it is a case of trying to explain to your managers that it really is for them to determine, given that it's from the business perspective here. And I do think that it helps to show your workings, because one risk of not explaining the rationale for your decision is that that's when there can be allegations that discriminatory motives are at play here. That being said, one thing we always say when it comes to these discussions, these internal discussions, is to be careful what you document, because more and more what we're seeing is a practice from claimants and claimant solicitors to make subject access requests when any claim is lodged, which can, effectively flush out any concerning emails which I'm sure you'll all be familiar with. An initial email from the manager to HR, which expresses their concerns about why this wouldn't work, which maybe suggests that the outcome is predetermined. If you do have any difficult or sensitive conversations to have internally, then make sure it is just over the phone, because the powers of disclosure when it comes to tribunal claims are wide and far-reaching, and what you don't want is an email to come back to haunt you, which could ultimately, ruin your prospects of successfully defending a claim. But I think when it comes to positioning yourself well to rebut any potential challenge, it is important to really drill down who is making the decision and why. So, whose remit is it, whose responsibility is it, and what are the reasons at play here, so that, you can show that you've gone through the right motions at the right time and aren't just doing this post retrospectively after a claim has raised to try and rationalise it effectively after the question's already been considered. I think this is where a right of appeal can be quite helpful, and it's indeed similar in other aspects of employment law. But the appeal should technically be to a more senior individual manager who is impartial, not previously been involved. And even the process of having an appeal whereby you understand the employee's perspective can really help flush out concerns and help you gauge the risk profile in terms of actually whether there could be grounds for a potential claim if it went that way, and whether you can take action now to stop that. And indeed, one of the cases we've seen in this area, that was the ultimate outcome, that the appeal was sufficient to overturn discriminatory motives previously at play at the initial stage, and as such it found in the employer's favour. So it's quite a useful tool from your perspective in terms of risk management. Okay, in terms of complaints and remedies from the employees if ultimately things go wrong, and it's always the lawyer to question what happens if things go wrong. So there is a right for an individual to raise a claim in the tribunal. It's 3 months within the decision being made, subject to the extension of time for early conciliation. But what I would say is there's basically quite a limited power from the tribunal to interfere with the decision. Ultimately, they have to assess whether the employer acted reasonably in dealing with the process, whether it did so within the time scales provided. But as I say, unless there are incorrect facts upon which it based its decision, it cannot really interfere or intervene with the rationale or the business reasons for the decision. And again, which is difficult from the employee's perspective, the penalties here are relatively small. So even if an employee can raise a claim and is successful with it, then even the penalties are relatively low. So the tribunal can order a reconsideration of the decision and also compensation. Compensation is capped at a maximum of 8 weeks' pay at a cap of £700 per week. So the maximum liability for a straightforward claim of this nature is £5,500. So I think some employers may think, well, what's the real risk? Rather just take the hit, and against that backdrop. But we have to be mindful of the potential for discrimination claims, which is the bigger hidden risk, I would say, when it comes to refusing requests. Separately, similar to other employment rights, an employee can raise a claim for detriment if they suffer a detriment as a result of having raised a claim, or indeed if they're dismissed and can show there's a connection between the raising of a request and their dismissal, then arguably that would be automatic unfair dismissal. And so the compensation for those sorts of claims is potentially uncapped, so could be much more sizable. But of course, separate to all that are the reputational ramifications as well of a claim. Regardless of outcome, it is possible for the press to pick up on the complaint and don't always wait for the judgment before they pass opinion. Okay, so common issues that arise in practice, and maybe one is the grounds for refusal and how to define the employer's decision in that respect. And as I say, I think it is quite helpful to rely upon more than one of the statutory grounds here, effectively hedging your bet and sort of making it a bit more difficult for a challenge to be raised if it was solely relying upon one ground. Another issue we see in practice is competing requests. So it's possible that you may have two requests in at the same time, or alternatively, it may be difficult because you've previously granted one that you're concerned about the floodgate argument or setting a precedent. That's often a concern that we do hear from employers. Well, ultimately, the law and the guidance in this area is quite clear that as an employer, you have the right to deal with cases and requests as they come in terms of if the first one comes in, you think that you can accommodate the request and you grant it. When the second one comes in, you're able to, as an employer, look at the context at that point in time, taking into account the fact that the previous request has already been granted. If that means that your options in terms of granting the second one is more limited, then that is a reasonable factor to rely upon. One thing that the guidance in this area suggests, which I'm not sure how common it would be in practice, or at least successfully done in practice, is it is possible to go back to the employees making the request and the previous employee to see if some sort of compromise could be met. So, if everyone wants a Friday off, whether you could do it on a rotational basis, for instance. But, ultimately, there's nothing obliging the first individual to agree. And so you are really just relying upon goodwill at that stage, which is quite difficult, particularly if you've already granted the request. There's not much incentivization on their part to prove willing. And as I say, one of the biggest issues when it comes to deal with flexible working is not a claim under the flexible working legislation itself, but rather a potential discrimination claim. And normally there is a number of potential risks in this area, but normally the biggest risk is that of indirect sex discrimination. And the reason for that is that in general, because ultimately indirect discrimination claims are all about generalizations, but in general, female individuals who are employees have greater childcare commitments and responsibilities than their male counterparts. And so if there is a blanket ban effectively of part-time working or remote working, which detrimentally impacts them as a group more than it does their male counterparts, then arguably that can lead to indirect sex discrimination claims. And I would say, much more often is that going to be the key risk profile from your perspective. It's unlikely that you would receive a claim for flexible working in itself without that being attached. Even if it was completely without merit, you can see that being raised from a tactical perspective to try and up the ante and put pressure on the employer to come to the table in terms of settlement negotiations. And the other potential ground for indirect discrimination claims is age, for instance. If an employee can show that a different approach is taken, whereby older workers are granted requests over younger workers or vice versa, and they can show there's a connection there. These sorts of claims ultimately can be defended if an employer can show that their actions were objectively justified, which the technical test is that they have to have had a legitimate aim and their policy or process, their actions have been a proportionate way of achieving that legitimate aim. So there are quite a few hurdles to come over. And what I would say is it's helpful, again, going back to what we've already touched on, to show your workings in this respect, because if you haven't gone through these thought processes and are silent on the matter, then it's much more difficult to defend these claims at a later stage, because the tribunals are live to post-rationalisation of the decision. Another potential discrimination risk, of course, is that of disability discrimination and an employer's duty to make reasonable adjustments. So this is one of the rare examples we see in employment law of a positive duty for you to take active steps to make adjustments to someone's working conditions or environment to remove or alleviate any substantial disadvantage which they experience as a result of a disability. And as you'll know, disability is defined quite widely under the Equality Act, so it can catch and include conditions which we might not otherwise have thought of historically as a disability. So again, that sits almost hand in hand with flexible working regime, depending upon the reasons for an individual's request. And it may be that occupational health input would have to be sought to understand exactly what impact a request granting or refusing would have on the individual and their health concerns. And of course, lastly here is the risk of a potential constructive unfair dismissal claim. And the primary reason for that is, as you'll be aware, when it comes to the employment relationship, there's an implied term of mutual trust and confidence which goes to the heart of every employment relationship. And if an employer has been said to have acted in such a way as to have damaged and effectively destroyed that implied term, then that can in itself be enough for an individual to resign and claim constructive unfair dismissal. So it means, when you are dealing with these processes, when you're refusing requests, when you're looking to make changes to T's and C's, that you're always being mindful of that, acting reasonably and effectively not giving the employee grounds for complaint in that respect. So in terms of flexible working in the modern workplace, that slide doesn't quite, oh, there it is, it's come up now. These are the issues that I'm seeing crop up more often than not, and I think it's perhaps a legacy and maybe a eventuality, a reality, arguably, off the back of the processes and steps that we've gone as a workforce, as a society, as a nation, off the back of COVID. Very quickly employers were having to put in place arrangements so individuals could work meaningfully during lockdown. And I think a number of those practices have continued. And there is now a point, I would say, in time where employers are really starting to question whether that's right going forward or whether they want to, pull back from that. And I think a large part of the concern in this area is to what extent can changes be made, or is there a concern that, as an example, as a result of custom and practice, there's an implied term on the employee's part that they can have this arrangement carry on indefinitely, effectively. So, questions now about whether employees can insist that they work from home, irrespective of the flexible working regime. Is there enough there for them to hang their hat on effectively? And indeed, the other side of the coin is, can employers insist employees return to their prior arrangements, even if, you have made accommodations and been a bit more flexible in the last few years than you would have done previously? And I think, ultimately it does boil down to, in the first instance at least, what is the contractual position, what has been agreed between the parties, what does their contract of employment say, if they have the opportunity to work from home or not, or are they based in the office. Of course, there are risks. There might be an argument that, irrespective of the express wording of a contract, that employees might have additional rights by virtue of custom and practice, such that there's an implied term that's been created over time. But what I would say is that it can be quite a difficult hurdle to overcome in practice. For a term to be implied through custom and practice, an employee would have to show that the term was reasonable, notorious, and certain, and effectively that there was a sense of duty or obligation on the employer's part to adhere to it as if it was contractual in nature. And those can be quite difficult hurdles to overcome if, it has been quite clear that the position is temporary in nature, that you've built in periods of review, that you've reserved the right to go back to what was gone before. But ultimately, if a change is contractual in nature, whether it's through express wording in the contract or as a result of custom and practice, then, as an employer, there are perhaps more limited options in terms of making changes. The first, as you'll be aware, which is always the most preferable and the one that we would recommend, is that you seek the employee's agreement to those changes. Becomes a bit of a selling exercise as to, what incentive is there on their part to do it. And sometimes it will be a bit of a communication piece in them understanding your perspective, understanding the concerns or the drawbacks with the current arrangement. That's definitely by far the best approach, because the alternative options open to you as an employer are then If you can't get agreement from the individual, unilateral imposition, whereby you make the changes regardless. Of course, there's a risk that, particularly given the nature of those changes, the impact they have on individuals personally, that they could claim constructive unfair dismissal on the basis of it being a breach of contract. Or your third option is, dismissal and re-engagement, which is fraught with risk and ultimately a lot of bad press over recent years. And indeed, there are looking to make changes as a result of the Labour government, which could really restrict an employer's opportunities in this respect. So not easy, and ultimately seeking agreement will ultimately be the best approach if you can get it. But yeah, I've just made the reference here in the third bullet point in terms of the implied term of mutual trust and confidence. Again, it goes to the heart of everything you do when it comes to your relationship with your employee. And so what I would say is, even if you're making changes that are contractual in nature or not contractual in nature, it's important to be mindful of this. So what it means in practice is, communicating with individuals, consulting with them, explaining your rationale, but also giving them time before any changes take effect so that you're mitigating the impact it has upon them. Okay, so in terms of key takeaways when it comes to flexible working, I think it does help to plan ahead and have a clear strategy, particularly if there's going to be a change of approach, that's being dictated at a macro level. What you don't want to get is a situation where, you're agreeing or accepting or refusing piecemeal requests, and then it's much more difficult for you to come back from that. So to have a clear vision in the first instance will be helpful to you in terms of being consistent when it comes to dealing with requests as and when they come in. But secondly, it is necessary to show your workings in terms of any individual requests. If you have that blanket policy of computer says no, regardless of the individual circumstances, then it really can expose you more greatly to claims of discrimination at play. And so, always wanting to understand the risk profile of any individual case and show your workings for why, in the specific facts and circumstances, it's not possible. As I say, the key risk here really is that of discrimination. So have that in your mind and indeed impress upon it internally as well, because I think that's sometimes where there's a bit of a disconnect in terms of managers perhaps not fully appreciating the risk profile. So there's probably a bit of an education piece as well there. And ultimately, as I say, with all these things where they can be contentious and potentially divisive, potentially create grievances or claims, employee engagement is key. If individuals feel that they've been properly listened to and dealt with respectfully and reasonably, then arguably it makes the likelihood of them raising a claim in practice much less. So, again, engage with individuals, show your workings, and that should help put you in a better position to take more robust decisions. So in terms of the Employment Rights Bill and the potential reform we're going to see under the Labour government, yeah, I mean, initially we had thought there could be wide-scale changes in terms of if Labour were to get into government, prior to the election as part of their manifesto, and indeed even once they were assumed into power, prior to the Employment Rights Bill being published, there was definitely a lot of noise from them that they would make flexible working the default. I remember hearing on the radio about 4-day working week for all. But then what we had was the Employment Rights Bill being published in draft form last autumn. And I would say that the proposals actually are arguably a bit of a damp squib. They're a lot less radical than compared to other aspects of employment law that Labour are seeking to reform. So in essence, there's no change to the reasons for refusal. So it's still those 8 statutory grounds. But rather than an employer just having to deal with the request, there's a more of an increased focus on the decision of the employer being reasonable in itself. So they have some more an extra step effectively to demonstrate that they have acted reasonably and the decision that they've taken is reasonable. And there's also ability for the Secretary of State to publish steps that would be required to consult with the individuals. prior to any decision being taken. But I think, there's definitely an argument that what they're suggesting in terms of the legislation is already just codifying what is in the ACAS code, insofar as, okay, the legislation right now doesn't require you to show your workings and explain the rationale behind your decision, but that is one of the things that ACAS code recommends in terms of demonstrating reasonableness in terms of how you've handled a request. So the reality is that will be done normally anyway. And likewise, when it comes to the consultation piece, again, most employers will be doing that anyway because that's one of the steps ACAS code suggests helps demonstrate reasonableness. So I think the reality is not much change really from a practical perspective. And interestingly, again, there's no changes being proposed to the penalties. So again, they're limited to 8 weeks' pay, which probably arguably undermines the employee in terms of the ability they have to affect change as a result of these proposals. So interesting. Obviously, we haven't got the final legislation. It's subject to scrutiny and rounds of debate in the Houses of Parliament. But I think the likelihood isn't going to be much change here from a practical perspective that would be too concerning. Thank you very much for joining us, and hopefully we'll see you at some of the other E3 sessions that we're running this year.